This is the most important legal information you need to know in order to get through your healthcare journeys without being taken advantage of. What is informed consent? There's a legal definition. There are 4 tenets to it. This is written by Dr. James Lyons Wheeler. He and I have talked a few times. He's one of the smartest people I've ever met. We had lunch. I talked to him about B1. So I've given him some very valuable information, and he's given us this incredibly valuable information. I'm going to read this word for word because I don't want to mess it up. That's how important this is. There are 4 things required by the U.S. Code of Federal Regulations for informed consent. Written by James Lyons Wheeler, PhD, February 10th, 2026. Modern medicine, driven by financial incentives and institutional pressure, has quietly abandoned informed consent and ethical restraint, transforming care into compliance enforcement, while convincing itself it is acting in patients' best interests. That's why one of the first papers I wrote was for the interagency harmonization on informed consent across all HHS agencies. So the Department of Health and Human Services has 27 agencies. Until those regulating informed consent do it right, nothing will change in medicine and public health. While HHS has many important competing agendas, this one ranks very high. Proper and legally obtained informed consent, per U.S. CFR, which is U.S. Code of Federal Regulations, requires all 4 of the following to be in place. Number 1, statements of the benefits and risks of any medical procedure, drug, or device. Number 2, an attempt by the physician to determine if the patient understands the benefits and risks. Number 3, an explanation of medically reasonable alternatives. Number 4, an absence of any threat of negative consequences to the continuance of care to the patient if they decline to provide consent, permission, parent, or assent, minors. Assent means agreement. Not an electronic tablet shoved in your face with, quote, sign here, unquote. These facts are supported by binding U.S. federal law and long-standing bioethics doctrine, not opinion. Here is the evidentiary foundation, point by point, grounded in U.S. Code of Federal Regulations and controlling legal standards. Informed consent is a protected human right in U.S. law. Now remember, people refused the COVID shot and they got fired from their job. New York City teachers, military people, and they sued afterwards and they won minimum $1 million. Some people $5 million. So you can't break informed consent. Informed consent is not a courtesy, workflow step, or administrative checkbox. It is a legal and ethical prerequisite to medical intervention, grounded in constitutional bodily autonomy and codified in federal regulation. 2 regulatory frameworks govern informed consent in the United States. Number 1, 45 CFR 46, Common Rule HHS Regulated Research, Public Health Programs, and Federally Funded Activities. And the second one is 21 CFR 50, FDA Regulated Drugs, Biologics, and Devices. Both impose substantive requirements that cannot be satisfied by electronic signature alone. Number 1, disclosure of risks and benefits is mandatory. Federal law requires explicit disclosure of both risks and expected benefits in language understandable to the subject. 45 CFR requires, quote, a description of any reasonably foreseeable risks or discomforts to the subject. Also requires, quote, a description of any benefits to the subject or to others that may reasonably be expected, unquote. Similarly, 21 CFR mandates the same disclosures for FDA-regulated products. Failure to disclose known risks, minimization of risks, or overstatement of benefits invalidates consent as a matter of law. It has to be informed consent, so if they give you bad information, then you're not being informed. Courts have repeatedly held that omission or distortion of material risk constitutes battery, not merely negligence. The definition of battery in law is intentional, unlawful touching or application of force to another person without their consent, resulting in harmful or offensive contact. This contact can include hitting, pushing, spitting, or even touching someone's clothing as long as it is intentional and offensive to a reasonable person. Battery differs from assault, which involves the threat or apprehension of imminent harm without actual contact. Battery completes the act. It is the actual physical contact. In criminal law, it is a misdemeanor, but it can be elevated to a felony if serious injury or deadly weapon or specific aggravated factors are involved. Number 2, the physician must assess patient understanding. Consent is not valid unless the clinician makes a good faith effort to determine comprehension. 45 CFR requires information be presented, quote, in language understandable to the subject, unquote. This requirement is not satisfied by presentation alone. Federal guidance clarifies that investigators and clinicians must ensure actual understanding, not passive receipt. The Belmont Report from 1979, which underlies the common rule, states explicitly, quote, an agreement to participate in research is valid only if voluntarily given by a subject who is adequately informed and has comprehended the information, unquote. Courts have reinforced this standard. In Canterbury v. Spence, 1972, the court held that informed consent requires information conveyed, quote, in terms the patient can understand, unquote, not merely disclosed. A tablet signature with no interaction, no questioning, and no comprehension check fails this standard. Number 3, medically reasonable alternatives must be explained. This is not negotiable. Federal regulations require disclosure of reasonable alternatives, including the option of no intervention. 45 CFR requires, quote, a disclosure of appropriate alternative procedures or courses of treatment, if any, that might be advantageous to the subject. 21 CFR contains the identical requirement. Courts consistently rule that failure to disclose alternatives, especially when risks differ materially, vitiates consent. Vitiates means spoils or lessens. Importantly, alternatives include delayed treatment, conservative management, non-pharmacologic options, declining the intervention entirely. If alternatives are omitted, consent is legally defective even if risks are disclosed. Number 4, absence of coercion or penalty is a core requirement of informed consent. Federal law explicitly forbids coercion, undue influence, or penalty for refusal. 45 CFR Common Rule requires that informed consent be sought, quote, under circumstances that provide the prospective subject sufficient opportunity to consider whether or not to participate, and that minimize the possibility of coercion or undue influence, unquote. This is not limited to overt force. Federal guidance defines coercion broadly to include implicit threats, power imbalance, and loss of access to benefits or services. So there are pediatricians that will refuse to see a patient if the mom decides not to vaccinate. That is against federal law. Crucially, 45 requires disclosure of, quote, a statement that participation is voluntary, refusal to participate will involve no penalty or loss of benefits to which the subject is otherwise entitled, unquote. So the physician must state that. You can decide not to take our care or our therapy. I won't fire you as a patient. This clause is dispositive. That means it settles disputes or property. If refusal to participate in the medical therapy leads to dismissal from a practice, denial of unrelated care, delayed treatment, labeling as non-compliant, threats of school exclusion, employment consequences, or medical abandonment, then consent is legally void. So they can't kick you out of school if you're not vaccinated. They can't kick you out of work if you don't do some medical treatment. And your medical doctor can't abandon you just because you disagree with the therapy that they're recommending. FDA regulations mirror this requirement verbatim. 21 CFR states, quote, no informed consent may include any exculpatory language through which the subject is made to waive or appear to waive any of the subject's legal rights, unquote. So there's no giving up your rights. The hospital can't write up some paragraphs and you sign a document saying, I give up my rights. They can't do that. And 21 CFR requires, quote, a statement that participation is voluntary, that refusal to participate will involve no penalty or loss of benefits to which the subject is otherwise entitled, unquote. So during COVID, it totally felt like medicine became the police state. And if you didn't obey what their demands were, you get fired. You couldn't leave your house. You couldn't go to work, et cetera, et cetera. That is a total police state. That is unconstitutional. It is completely federally unlawful. There's no governor. There's no politician that had any right to make you stay at home, to make you lose your job, to make you lose your medical care, to make you not go to the hospital. Nobody had any right to stop any of that. Loss of access to care is a loss of benefit. Threatening dismissal from care for refusal constitutes undue influence under FDA rules. OHRP, which is the Office for Human Research Protections under the Department of Health and Human Services, has this guidance: refusal cannot affect access to care. So the HHS Office for Human Research Protections has repeatedly clarified subjects should not be pressured to participate and should not be threatened with loss of benefits or services to which they are otherwise entitled. This includes medical care, especially when the physician controls access. A physician who conditions ongoing care on acceptance of a procedure invalidates consent by definition. So if they require you take their procedure or do their therapy, and they say, if you do this, I'll keep seeing you, then that is not informed consent. Minors. Coercion is even more tightly prohibited. This is very interesting. For children, federal regulations are stricter, not looser. 45 CFR requires parental permission and child assent. Where appropriate, assent means agreement. 45 CFR makes clear that dissent by a child must be respected unless a narrowly defined life-saving exception applies. Threatening a child with school exclusion when no mandate exists, loss of care, authority-based pressure, constitutes coercion of a vulnerable population, which is an ethical red line. Courts treat coerced consent as no consent at all. U.S. courts consistently hold that consent obtained under threat or pressure is invalid. In Canterbury v. Spence, 1972, the court emphasized that informed consent requires free choice, not acquiescence to authority. More broadly, consent obtained under duress converts a medical intervention into battery, regardless of intent. This is why modern lawsuits correctly frame these cases as battery, false imprisonment, fraud, not malpractice. Why, quote, sign here or find another doctor, unquote, fails legally. Dismissal threats exploit a power imbalance. Physician controls access. Patient is dependent. Refusal carries consequences. That is undue influence, even if spoken politely. A consent process that includes any threat, explicit or implied, of negative consequences to continued care is not informed consent under U.S. law. Electronic consent does not replace substantive consent. HHS guidance is explicit that electronic or written consent does not substitute for the informed consent process itself. HHS OHRP guidance from 2016 states, informed consent is a process, not a form. The clinician remains responsible for explanation, assessment of understanding, opportunity for questions, absence of coercion or undue influence. A tablet sign here workflow satisfies documentation, not consent. Legal consequence of failure, battery, not paperwork error. When informed consent requirements are not met, courts treat the intervention as unauthorized touching. This is why modern lawsuits correctly are pivoting away from injury causation and toward battery, fraud, false imprisonment, deprivation of civil rights. These claims do not require proof of injury, only proof that consent was invalid. Bottom line, legally and ethically, informed consent is a human right embedded in U.S. federal law. It requires disclosure, comprehension, and alternatives. Anything less is coercion dressed up as care. Until HHS agencies harmonize enforcement of 45 CFR 46 and 21 CFR 50 as written, rather than as administratively convenient, medicine will continue to drift toward institutional authority over patient autonomy. And no amount of cause for convenience for healthcare workers, providers, medical professionals, technology, or public messaging can override that reality. How you can help right now, share this with a loved one. So this is on Substack. The name of this Substack is called Popular Rationalism by Dr. James Lyons Wheeler. So we never get to the point where you sign an informed consent form. Make sure you read it and understand it. Ask the administrative staff or the doctor, what am I signing? What does this say? I have a question on this line. Don't be rushed through this. I know as Americans, we're so trained to just sign documents. Like when you buy a large purchase like a house, you can sign documents for 45 minutes. And we're trained to just go on and on like that. But when it comes to your physical body, what else is more important than your health? Know exactly what you're signing. And if they threaten you, oh, if you don't sign that, you won't get your care that you need, or we're not going to see you anymore, we're not going to see your family anymore, that's battery. That's not legal at all. Informed consent is how you keep the autonomy of your body in control. It's your body. Nobody else has any right over it or to force any kind of therapy on you. If you can't control your body, what else is there? RFK Jr. says a sick person has one dream, a well person has 1,000. And the more medications you're on, the sicker you get. If you're on 5 or more medications, that's called polypharmacy. That means you're going to die sooner and you are sicker because of the medications. All medications are poison. They're designed to block receptor sites and destroy enzymes, and they do things that stop. They don't do anything to enhance or to nourish or to build or to make healthier or stronger. They weaken and they stop, and the more you take, the sicker you get. That's the bottom line. Take your power back. I hope this helps.